Films and Publications Act prohibits two types of child pornography. The first type, real child pornography, involves actual children. This is the type of pornography that evokes a strong and near universal sense of moral outrage. It is not only the material that is offensive, it is the permanent record of a particularly vile form of child abuse. Children that are involved in pornography are harmed by its creation. The distribution of the material is a further harm against their dignity and privacy. During the course of this presentation, I will discuss why the state is justified in instituting criminal sanctions for the production, distribution, and possession of this type of child pornography. Legislation also takes aim at another form of child pornography. This type does not involve real children. This virtual child pornography is made up of a number of different types of erotic material. It includes paintings, cartoons, sketches, and written descriptions of children involved in sexual conduct. It also includes depictions of adults, which are represented as being under the age of 18, engaged in sexual conduct. Digitally created images that resemble actual child pornography, but which do not make use of real children, are also prohibited. I will argue that while certain forms of virtual child pornography are offensive, the state is not justified in instituting criminal sanctions against those that produce, distribute, and possess it. The penalty for both types of material is currently a prison sentence of up to 10 years for the production, distribution, and possession of the material. It is therefore possible for a person to be imprisoned for a period of up to 30 years if he or she is liable for all three offences. I will now move on to discuss real child pornography. The state has a duty to uphold the right to freedom of expression, but it must also place appropriate restrictions on this right in certain circumstances. Real child pornography serves as a record of a particularly severe rights violation. The producers of child pornography actively participate in the sexual exploitation of minors. Younger children lack the capacity to fully appreciate the magnitude of what they are involved in and cannot be considered consenting parties to sexual conduct. Real child pornography lasts as a haunting memory of abuse and a continual source of harm to the children that were involved in its production. The distributors of this material play a lesser but significant role in the perpetuation of this form of child abuse. They stimulate a market for real child pornography and encourage its creation. By encouraging a greater demand amongst consumers, they incentivize pornographers to increase the supply of materials. Consumers are not without blame in this process, since they provide the capital incentive for people to continue to produce and distribute real child pornography. I would argue that there is a sufficient connection between the production, distribution, and possession of real child pornography and the abuse of real children to warrant the criminal sanctions against real child pornography that are currently in place. This is a clear case where freedom of expression can be limited to prevent significant harm to children. However, the law ought to recognize that producers, distributors, and possessors are not deserving of equal punishment. A possessor is not as intimately linked to the abuse of children, of a child, as the person that actually molests a child and films that molestation. I would suggest that a blanket punishment for the three categories of offenders is inappropriate, since it fails to distinguish between the levels of harm caused by the offenders. There is arguably a case for exempting couples that are above the legal age of consent, but younger than 18, from being punished for producing erotic images of themselves. It seems unjust to sentence a 16-year-old to 30 years in jail for taking erotic photos with her lover, sending it to him and retaining a copy for herself. I will now move on to discuss virtual child pornography. Virtual child pornography does not involve, let alone harm, any children in the production process. The statute prescribes the visual depiction of an idea, that of teenagers engaging in sexual activity. That is a fact of modern society and has been a theme in art and literature throughout the ages. The law specifically states that artistic forms and publications are not exempted from prohibition if they constitute virtual child pornography. In order to illustrate the severity and extent of the prohibition, I will endeavour to provide a short list of materials that would incur criminal sanction under the Act. Paintings by the prominent and well-respected artists Gustav Klimt and Egon Schiele. Numerous sculptures and sketches produced during the Renaissance period. The most famous love story ever written, Romeo and Juliet, involves a relationship between two teenagers, one of whom is only 13 years old. Several adaptations of the play have been produced for film, and some of them show the lovers involved in sexual conduct. The recent Oscar-winning films Traffic and American Beauty both feature scenes depicting women under the age of 18 involved in sexual conduct. All of these valuable and beautiful works of art are examples of child pornography as defined by the Act. It is not only existing works that would suffer the force of censorship. The act would have a chilling effect that would prevent new works of art from being created. A 14-year-old high school student could be imprisoned for a period of up to 30 years if she drew a cartoon or painted a picture of herself involved in sexual conduct, distributed copies to her friends, and retained a copy for herself. The examples that I've used provide a basis for the conclusion that virtual child pornography is drastically different from real child pornography and ought not to be regulated in the same manner. I will now turn to a series of arguments which defend the prohibition of virtual child pornography. I will demonstrate that these arguments are ultimately unsuccessful. Firstly, it is argued that virtual child pornography may be used to entice children to have sex with pedophiles. This argument fails on the basis that innocent objects like cartoons and candy may be misused by pedophiles to achieve the same end as seducing children, but we do not think that it would be appropriate to prohibit these items. Secondly, in some cases it is not possible to distinguish virtual child pornography from real child pornography. This will be the case where adults are made to look younger than the age of 18, or where images are created through the use of digital imaging software, which does not make use of performers at all. It is therefore argued that in order to prosecute real child pornographers, it is necessary to prohibit the virtual counterpart. However, if it really is the case that a certain class of virtual images is indistinguishable from real images, the illegal images would be driven from the market by the indistinguishable substitutes. Few pornographers would risk prosecution by abusing real children if fictional, computerized images would suffice. It seems that virtual child pornography would have the positive effect of reducing the amount of real child pornography being produced. It would in fact be saving children from suffering abuse. Thirdly, it is argued that virtual child pornography will encourage pedophiles to abuse real children. In order to address this argument, I will provide a discussion of the empirical evidence on this matter. There are 4 types of evidence that attempt to show the link between pornography and violence against third parties. Firstly, there are laboratory experiments that show how exposure to pornography affects the behavior of men. Secondly, studies that describe the factors that play a role in causing sex offenders to commit crimes. Thirdly, statistical data that seeks to correlate the availability of pornography to acts of sexual violence. Finally, there are anecdotal accounts that detail the role played by pornography in cases of sexualized violence. Such accounts are typically from testimonies made by victims and perpetrators of sexualized violence. Laboratory experiments are conducted by exposing subjects to pornographic images and assessing the levels of sexual aggression that are caused by the exposure. Numerous studies have failed to produce reliable results that prove that being exposed to pornography causes sexual aggression. The experiments are only able to show that being exposed to pornography caused subjects to revise their beliefs about how common certain sexual practices were. Studies that have been conducted on sex offenders show that those men have been exposed to less pornography than the average man. Furthermore, a large number of sex offenders were raised with strict, anti-sexual, repressive attitudes. This seems to suggest that it is healthier for a person to be exposed to pornography in an environment that supports sexual expression, as opposed to one that condemns such expression. It is obviously the case that some sex offenders were also users of pornography. However, using this evidence to support the claim that using pornography causes one to rape is as fallacious as using evidence that shows that some rapists are soccer players and suggesting that playing soccer causes people to rape. The number of people that play soccer or view pornography that do not commit rape far outweighs the numbers that do. Studies that show a relationship between an abundant use of pornographic materials and high levels of sexual violence would not in themselves show that consumption of such materials caused sexual violence. The chain of causality could run the opposite direction. It could just as well be the case that sex offenders purchase pornography after committing their crimes in an effort to relive their actions. There could also be independent factors that cause high levels of consumption of pornography and sexual violence, like a disproportionately high number of young men in the society. In addition to these problems, there are numerous cases where there is an inverse relationship between the levels of violence and discrimination against women and the level of availability of pornography. In countries like Japan, Denmark, and Germany, there are very low levels of violence against women, despite the fact that pornographic materials are easily accessible in these countries. On the other hand, in countries like Iran and China, where women are frequently subjected to violence and discrimination, there are strict policies against pornography. This is not sufficient evidence to show that an increase in pornographic materials decreases violence against women, but it does show that there are independent factors that affect both sets of data. Tolerant environments that place fewer restrictions on freedom of expression tend to allow for more pornography to be produced. but they also reduce the levels of violence and discrimination against women.